In 2026, the Supreme Court struck down Executive Order 14160, ruling that children born in the U.S. to temporary or undocumented immigrants are citizens. The final vote was 6-3 against the executive order, but that top-line number obscures a fractured court. On the underlying constitutional question, the justices split 5-4. This document shows Section 1 of the 14th Amendment. The Citizenship Clause reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens." The ideological divide centers on 7 words, "and subject to the jurisdiction thereof." The bench broke into factions over 2 distinct definitions of jurisdiction. One branch interprets the phrase as requiring territorial presence. The other interprets it as requiring political allegiance. Resolving which definition applies dictates exactly who holds the power to confer American citizenship going forward. We can map the court's factions into a 3-column matrix based on their legal logic. We have a 5-vote majority, a single-vote concurrence, and a 3-vote dissent. Column 1 is led by Chief Justice John Roberts, who authored the majority opinion. This group represents the territorial view. Roberts anchors his argument in the English common law principle of jus soli. This translates to right of the soil, the rule that birth within a physical territory automatically confers citizenship. The Reconstruction Congress drafted the 14th Amendment specifically to codify jus soli into the Constitution. Their immediate goal was to permanently overturn the Dred Scott decision, which had denied citizenship to African Americans. Dred Scott relied on an opposing legal framework known as jus sanguinis, where citizenship is determined strictly by blood and ancestry rather than geography. To support the modern application of the territorial view, the majority relies on the 1898 Supreme Court precedent, United States v. Wong Kim Ark. Wong Kim Ark confirmed that the 14th Amendment recognized only a fixed, historically narrow set of exceptions to birthright citizenship. These exceptions apply to children born to accredited foreign diplomats or members of an occupying enemy army. Because temporary visitors and undocumented immigrants do not possess diplomatic immunity and are not hostile military forces, they remain subject to U.S. laws and courts while physically inside the country. Therefore, they meet the requirement of being subject to U.S. jurisdiction. Under the majority's logic, physical birth on American soil activates citizenship. The parent's immigration status has no bearing on the constitutional standard. Moving to the second column of our matrix, we find the dissent, which advances the political view. Justice Clarence Thomas leads this group with an originalist counterargument to the majority's reading of history. The dissent argues that the 14th Amendment was drafted with a highly specific scope, providing citizenship to freed slaves. These individuals already possessed permanent American domicile and called the country home. Under this framework, being subject to the jurisdiction requires more than mere physical presence. It requires complete political allegiance to the United States, a standard that temporary visitors and undocumented immigrants do not meet. The final column isolates Justice Brett Kavanaugh, who represents a purely statutory view. Kavanaugh provided the crucial 6th vote to strike down the executive order. However, he refused to join the majority's constitutional ruling. He concluded that the executive order was invalid simply because it conflicted with the Immigration and Nationality Act of 1952, an existing federal statute that governs citizenship at birth. Kavanaugh reasoned that the framers in 1868 could not have anticipated the complexity of the modern immigration system. By relying on a statute instead of the Constitution, his opinion explores the possibility that Congress might have the authority to write new rules. Because Kavanaugh took this statutory off-ramp, the court failed to reach a unanimous constitutional consensus. That single missing vote creates a theoretical opening for future legislative battles over birthright citizenship. Immediately following the decision, political figures claimed that Congress could resolve the issue by passing standard legislation to end birthright citizenship. This diagram illustrates the hierarchy of United States law. At the apex sits the Constitution. Below that are federal statutes passed by Congress. At the base are executive orders issued by the President. Executive Order 14160 failed because an action at the base of the pyramid cannot overwrite a federal statute. If Congress passed a new statute attempting to redefine citizenship, it would face an unforgiving structural barrier. That new law would immediately hit the absolute ceiling of the 14th Amendment, enforced by the 5-vote bloc established by Chief Justice Roberts. The Supremacy Clause dictates the mechanics of our legal system. An ordinary act of Congress cannot override a constitutional guarantee. The 14th Amendment functions as a constitutional floor that permanently protects jus soli. It is not a statutory ceiling that a legislative majority can lower at will. Because of this hierarchy, the only valid legal mechanism to alter birthright citizenship is a formal constitutional amendment, a process requiring supermajorities in both chambers of Congress and ratification by 3/4 of the states. Despite the institutional friction and a divided court, the 14th Amendment executed its precise function. It has successfully placed the definition of citizenship out of the reach of ordinary legislative and executive politics.